So I think we're ready to go. And Madam Clerk, let's call the first case.
In re Solano, Jose R. Solano, appellant in pro se. Larry Rothman, counsel for Appley Orange Kangaroo, LLC.
Okay, why don't we
Good morning,
go
Your
ahead and take appearances? Okay, go ahead. Tell me your name.
Jose Solano, appellant.
Okay. And you want to reserve some time?
For rebuttal,
Honors.
for rebuttal, about 5 minutes.
About 5 minutes? Okay. All right, go ahead. We're going to get an appearance from Mr. Rothman. Go ahead.
Yeah, good morning, Your Honors. Larry Rothman for the appellee, and I apologize for not being on video, but I had eye surgery yesterday.
Okay.
And bandaged up.
Okay. Well, I hope you're doing well. Okay. So
I
I'm
am.
sorry.
Thank you, Your Honors.
Okay, you bet. Okay, so 5 minutes for rebuttal? Okay, you may proceed.
Yes, sir.
Okay, thank you, Your Honors. I just want to, this case arises from a bankruptcy court that was trying to seek protection from a civil action in a lawful detainer case. Through discovery in the unlawful detainer case, we discovered that the respondent did not purchase the property, nor did they have title to the property. So, based on those findings of fact, even though it presented to the court in a lawful detainer court, they did not. They ignored my pleadings and issued a judgment in favor of the respondent. Now, I was seeking bankruptcy protection to figure out how I could adjudicate this case based on the the abuse of discretion from the court. Upon doing so, the respondent filed a motion to lift the stay. Judge Rizzolo pretty much violated my bankruptcy rights by one, lifting a stay, even though the transcript showed I informed the court that that the appellant did not have proof of purchase and they do not have title to the property. He also ignored my pleadings by still focusing more on discussing a case he had co-authored with a pending case. Mr. Rizzolo went to extreme prejudice to deny me also the 14-day stay. He checked off one box to deny me that, and further went to check off box number 14, where he states, and I quote here, it is further ordered that Movement it is authorized to regain possession of Movement's property pursuant to the ruling in reference to Smith, despite the finding of this and any other bankruptcy petition. So he pretty much stopped me without even considering my pleadings. And if you look at the transcripts, he just said, okay, thank you, and no consideration whatsoever.
So, Mr. Solano, I have a question.
Yes.
So, you started this argument with telling us that there had been an unlawful detainer action in state court that had proceeded,
Yes.
and it had proceeded to a judgment.
Yes.
Did you appeal the judgment?
I am in the process of doing so, yes.
So there has not been a final determination
No.
on the appeal?
No.
The unlawful detainer action was commenced by Orange Kangaroo?
Yes.
And it was based upon their claim that they had ownership of the property and a trustee's deed?
That's
from
what
the
they claim, yes.
And that's what you challenged in front of the state court?
I did.
And it was based upon the judgment that the bankruptcy court found that there was a colorable claim for the lender, for Orange Kangaroo?
Right. Despite showing, in fact, in the unlawful detainer action, you're allowed to challenge the trustee de Ponceo, and the court ignored. I had 7 pleadings. They were all denied. And so...
Well, you also, didn't you, removed the unlawful detainer action at some point to the district court?
I did.
And the district court remanded it back to the unlawful detainer court?
Yes.
And you also removed the unlawful detainer action to the bankruptcy court, and the bankruptcy court didn't take any action?
Right, because I filed an action to recuse the judge for her actions.
Okay.
Now, in the interim, there's been a writ of possession already issued and could be executed any time. So, okay, I'm sorry. Okay, so Judge Rizzolo did not ask the respondent if there were had any merit or anything of sort. He ignored my opposition, denied me due process. In fact, Mr. Rizzolo made no findings of fact in his ruling, which is required to do so. So I have 5 issues I want to bring up. The first one, again, as I mentioned earlier, Under Federal Rules of Procedure, a contested motion for relief from that stay requires the Federal Rules of Bankruptcy Procedure 7052 that the court take evidence and issue its findings of fact and conclusions of law, which he did not. The court ignored the equitable and possession interest in the property, continued the possession of the property, pay utilities, activating and challenge the title, and so they evoked protection under 11 U.S.C. 362. And the Ninth Circuit has ruled that has held that when the debtor's mere possessions of real property is protected, interest under the automatic stay.
I'm gonna tell you here, I think the rule's a little bit different. I don't know what case you're citing, but In re Pearl generally stands for the proposition that the mere possession of property is not significant for automatic stay purposes. So if you want to go ahead and make your next point, go ahead and do that.
Yeah, okay. Well, that's the research I found.
Okay, I appreciate it.
3, the order was entered while my motion to cancel the trustee deed upon sale was pending and unresolved. That motion directly challenged my claim title, and the court's decision to proceed without resolving it was premature and prejudicial. Point number 4, the court waived the 14-day stay under FRB 4001, allowing immediate eviction and creating irreparable harm and practices mootness to my appeal. The Supreme Court has held that preservation of the status quo is essential to meaningful appellate review. And finally, the bankruptcy court denied my motion for stay pending appeal without issuing any findings of analysis of fact. The court's failure to make a finding of state of rationale for its ruling constitutes irreversible error. As I mentioned before, there is an active writ of possession. I may be evicted any time for a property that respondent did not either purchase or have title to. Again, my pleadings went unheard. The record lacks the factual and legal foundation necessary to support relief from stay. According to this panel, should reverse the order and remand proceedings consistent with law and due process. Thank you.
Okay, thank you. Any questions?
No.
Okay, you can reserve the rest of the time to respond to Mr. Rothman if you like.
Okay.
Okay. Thank you so much. Okay, yes, go ahead. Yeah, relax for a minute. Okay, Mr. Rothman, can you hear us?
Perfectly. Your Honors, I didn't hear anything in the appellant's argument that was in addition to what he had set forth in his brief. So with that, Your Honor, I would not add anything.
Oh, okay. Anyone on the panel want to ask Mr. Rothman a question?
Well, Mr. Rothman, he asserts that you didn't have a valid sale. Can you explain why you believe the sale resulted in a valid transfer of title to your client?
Because it was a foreclosure sale, and he's basically challenging it that it wasn't invalid money because of what the documents that set forth just showed a copy of a cashier's check and not a actual cashier's check itself. And that not only in the remand order, but in the judgment when he sued the Orange Kangaroo in district court, the chief judge, Dolly G., ruled in the final judgment in the district court that there was his complaint was dismissed without leave to amend, that Orange Kangaroo had title. I apologize, Your Honor. The anesthesia is still kind of affecting my ability to speak.
Well, you take your time, okay? You've got 15 minutes. Take your time.
And with that, Your Honor, that is the reason that I believe, and all of that occurred prior to the relief from stay motion. These occurred and were brought forth in a request for judicial notice. I can't recall if it was in the relief from stay, but Mr. Solano had filed an adversary case also, and then also removed the case to Judge in the Riverside, Judge Burnell, a district court judge, who claimed that in his removal to that, claimed that Judge Zorro didn't have jurisdiction to even rule in this, which came later. And based upon all of the judge's rulings that were subsequent, and all of the rulings that occurred in this case and subsequent to this hearing, it seems that without a question that title was passed legally to Orange Kangaroo. And with that, Your Honor, I would submit.
Okay, anybody have any further questions?
The one question that I have, Mr. Rothman, is that the court said that there was relief from stay in this case and a subsequent bankruptcy case. What's the basis for granting the relief from the subsequent bankruptcy cases?
Okay, in the subsequent bankruptcy, there was a request that Mr. Solano had filed a request that the relief, there was a subsequent motion by Mr. Solano, and my memory's a little bit not as great as it should be, but I don't believe it's in the record that Judge Azoro granted by himself in order that no additional relief would be granted to him. And I guess that would be construed to be that there would be no additional relief from stay. Maybe, so there was, I think it would be it, but it may be construed to be two relief from stays for the same bankruptcy. I know that there was a whole bunch of notices of removals that were removed back. I think there was almost a Guinness Book of Record of removals in this case.
But, Mr. Rothman, you moved for stay relief under D1, 362 D1. You didn't move for stay relief under 362 D4, correct?
Correct. And by the way, I'm glad you brought that up, Your Honor. I did not ask for in rem because the first time you can't.
No, I'm not questioning that you did anything
That's my
wrong.
knowledge of the law.
I'm just trying to make sure that to the extent that Judge Zerzolo may have granted more relief than you asked for, we may want to take a look at that. In other words, if he granted, if his order could be construed to have granted in rem relief, that's not something you sought.
I did not seek in rem, and I don't believe you can the first time.
Right. Okay.
Also, your client was the owner of the property at that point?
Yes.
Well, they
I
can't.
apologize for interrupting.
That's another
Your
reason
Honor.
why, right? I mean, it's secured lenders get to ask for D4 relief. So.
That you have to be a secured lender.
Yeah. Okay. Okay. Any other questions?
None from me.
Okay. All right. Thank you so much, Mr. Rothman. Hope your eyesight improves.
Thank you, Your Honors.
Okay.
Thank you, Your Honor.
Okay, and we're going to let Mr. Solano come up and have the last word, okay?
Thank you, Your Honor. Just a commentary on Mr. Rothman's comment regarding the district case. By the way, it's the circuit. It's case 24-01587. Judge Dolly G. She did grant ruling without leave to amend, but in her write-up, she had several causes of action that were dismissed with prejudice and others without prejudice. Yet she overall denied no leave to amend, granted no leave to amend, which is contradictory. That's grounds for appeal also. So that case, we did a motion for reconsideration. That's still pending. Just want to clarify that. So
Okay.
the case is still active.
Okay. Is there anything else?
That's it. Thank you.
All right, then the matter's submitted, and thank you for your good arguments for Mr. Rothman and Mr. Solano, and we'll do our best to get you a written decision as soon as we can. Thank you very much.
Appreciate it. Thank you.
Okay, you're welcome. Okay, it's
Thank you.
call.
Thank you, Your Honor.
You bet. Thank you, Mr. Rothman. Okay.